A company's failure to have a reasonable and consistently implemented litigation hold procedure can expose it to significant risk and damages in litigation. What can companies do to protect against the risk of losing evidence? That's today on Liability Watch. Welcome to Liability Watch. I'm Shelby Neal. A number of recent court decisions have imposed significant monetary and other sanctions on companies for losing or destroying evidence as a result of inadequate or poorly implemented litigation hold processes and procedures. Last year's widely followed Actos products liability litigation in Louisiana highlights these issues. In that case, the judge found that the manufacturer had lost or destroyed evidence in bad faith. The judge's decision stemmed from a litigation hold the manufacturer had issued in a different products lawsuit almost a decade earlier, but unfortunately it hadn't released that litigation hold when the earlier litigation resolved, and so the judge concluded the manufacturer should still have that evidence. Because it didn't, the court told the jury it could assume that the lost evidence would have either helped the plaintiff's products liability case or hurt the manufacturer's defense. As you might guess, the jury ended up imposing significant actual and punitive damages against the manufacturer. Today we'll hear from Sherry Aberly, a commercial litigator at Dorsey & Whitney, LLP, who will discuss the steps your company can take to make sure its litigation hold process best protects against the risk of data loss and allows the company to keep the focus in litigation on the merits. Sherry?
Thank you, Shelby. It's not uncommon for plaintiffs' attorneys to try to find shortcomings in how a company has preserved evidence in litigation. When those errors are found, the consequences can be game-changing, ranging from monetary damages to an adverse inference, like in the Actos case, to even entry of judgment against the defendant. The Actos case is one example that highlights the importance of making sure the company's litigation hold process is thoughtful and effective from start to finish. The first step is knowing when to issue a litigation hold. This isn't always a straightforward inquiry, and the triggering event or events can sometimes be hard to pinpoint. There are a number of different facts that might play into the decision of whether to issue a hold, and often those facts are in the hands of managers, supervisors, or even line employees. So it's important that the company's employees are trained and regularly reminded on the company's legal hold policy and procedures. They don't need to know all of the factors or be the decision makers, but they do need to know enough to be thinking about the issue, understand why it is important, and know who they should talk to if they think litigation or an investigation or audit might be possible. Once the decision is made to issue a litigation hold, you need to be thoughtful about the scope of that hold. The company isn't required to preserve everything, only what's relevant. This is a balance. You don't want to expose the company to unnecessary costs by over-preserving irrelevant evidence, but you also don't want to risk losing relevant evidence by under-preserving. To strike that balance, you need to get your arms around the facts quickly to identify the employees who are likely to have relevant information, as well as the systems, databases, and other likely sources of relevant information. You should involve your IT and make sure you are thinking about new and dynamic forms of evidence like mobile devices, data stored with cloud computing providers, social media evidence, and evidence on employees' personal computers and devices, to name a few. The next step is actually issuing the litigation hold. It's a good idea to provide some type of training so employees know what to do. And while it should be obvious, it's not enough to just issue the hold. You need to make sure employees are complying and that you're documenting that compliance. After the hold is issued, you should have a system in place to monitor the hold, to provide regular reminders, and to address changes in scope as the issues evolve through the course of litigation. All of this should be documented as well. Finally, make sure you have a system in place to release the litigation hold once your obligation to preserve has ended. Before you release evidence from an active hold, make sure it isn't needed for other litigation or subject to other legal holds. In the end, you want to have standard documented procedures that the company consistently follows for its litigation holds from start to finish. This will go a long way to help show the company's good faith compliance if a spoliation claim is ever made.
Thanks, Sherry. To request a copy of Dorsey & Whitney's Best Practices Litigation Hold Preservation Checklist, follow the link on the screen. If you'd like more information on protecting your company from the risks of inadequate litigation hold procedures, contact Sherry or visit dorsey.com/productsliability. I'm Shelby Neal for Liability Watch. Thanks for watching.